appeal is the matter of Ashraf and Dominic Solicitors and others.
I must apologise for the cold. The heating is not functioning. We are assured that an engineer is on site and attending to it. I can't promise when we will get some heat, but there it is. So, Mr Brown.
My Lord, speak for myself, I hadn't noticed the temperature will be fine. Round for the appellant, Mr Cousins in counsel, and Mr Dodge for the respondent, the seventh defendant, Reese Page. Hopefully the court has an appeal bundle, supplementary bundle and authorities bundle.
Yes.
My Lords, this is an appeal against the order of Mr Justice Edwin Johnson, dated 27th June 2022, for page 82. The judge dismissed an appeal against the order of Deputy Master Lloyd, dated 13th of December 2019, for page 228. My submissions today are going to be structured as follows. I'm going to make a brief introduction to the issues on appeal, and then I'm going to structure my substantive submissions in three parts. So first, I'm going to set out the essential factual framework as it stands at the moment. Secondly, I'm going to make submissions as to the legal principles engaged on the appeal in relation to the issue of duty of care. And thirdly, I'm going to make submissions as to why, on a proper understanding of the law, the Deputy Master and the judge were wrong in their treatment of the law and wrong to enter summary judgment against my client. With that, then, my Lords, if I may just outline the following. This, we say, is a very unusual case with very unusual features. It concerns two successive frauds perpetrated within the general framework of a property conveyance transaction. In the first fraud, my client was defrauded by his solicitors, FLP, in a transaction in which he was a willing participant. And I say that FLP were his solicitors. It is right to note that at the time they were also the purchaser's solicitors, the third defendant, and they were also the bank's solicitors. The bank is the sixth defendant. The circumstances of the second fraud are critical to this appeal and action, and those circumstances are rather less clear, and I will show the court what we know in a moment. If I can just make the following observations. In contrast to the first fraud, my client was not a willing participant to the transaction which gave rise to the second fraud. That transaction was orchestrated by the respondent, Reese Page, and its client, the bank, and it was imposed upon my client, we say, despite the obvious existence of multiple indicators of concern or red flags. And the short but potentially complex issue that is engaged on this case is whether, if the facts that we say arise here, if those facts are proven, whether they are capable of giving rise to an assumption of responsibility on the part of the solicitor to my client, notwithstanding the fact that my client was not the client of the solicitor.
I understand why you characterise this as a transaction orchestrated by the respondent and the bank and imposed on your client. And at the moment, that seems to me to be a rather justifiable way of looking at it. But that being so, is it not a little counterintuitive to say that the respondent owes your client a duty of care?
Well, counterintuitive as a starting point, yes. Does that mean that it is not possible as a matter of law there to be a duty of care in those circumstances? No. I mean, we're within what is described in the authorities as the exceptional cases. So in due course, we're going to go to the decision of this court in P&P Dreamvar, we're going to go to the decision of the Supreme Court in MRAM, we're going to look at 6 previous authorities, all of which concern precisely this situation, namely solicitor liability to a third party. And every time this court or the Supreme Court looks at it, it is described as being exceptional. And we accept that. So we're within the territory of an exceptional set of cases where, notwithstanding the absence of a contractual relationship, there is nevertheless an assumption of responsibility to a third party. And this has been well accepted on the authorities for many years. So all I need to show, given that we are still at summary judgment, is whether it is arguable on the summary judgment threshold that there is such an assumption. We put it in different ways. Where we put it in skeleton argument is that if one has a situation, for example, where a solicitor has a retainer to do one thing, but performs it in a manner which knowingly or perhaps reasonably foreseeably has the consequence of riding roughshod over the rights of another, why is it that the law would not have fixed liability in those circumstances? Now, it may be that it doesn't, but that would be a matter for trial. All I need to persuade this court of today is that it is arguable that in those circumstances there could be a duty. That's it. That's all I need to show. So that's my direct answer to the court's question, and the court is obviously right to pose it to me because that's at the heart of all of this. But we do need to look at the documents. We need to explain why it is that this case is within that category of unusual cases. The circumstances, by way of overview, are this, and the court will have seen this from the reading. The seventh defendant, through Mr Gilbert, sought to procure from Mr Ul Haq a backdated transfer deed so as to regularise the consequences of the first fraud. So that was the mechanism. What is more, though, what was ultimately submitted to the land registry was a false AP1 application form which suggested that my client was represented by solicitors, i.e. other solicitors, in this second transaction, when, of course, he was not. And our case is that the solicitor did not take proper steps to ascertain whether Mr Ul Haq was a willing participant to the transaction. And by his actions, he brought himself into a legally proximate relationship with Mr Haq. So the starting point is that this is not a conventional property conveyancing transaction. This is not PMP, so we are not shut out by the conclusions of this court in PMP, which concerns an ordinary arm's-length conveyancing transaction with parties who are represented in the ordinary way by their own solicitors. This is far from it. So this is not the paradigm, I emphasise that. This is the exception. The first fraud and the first transaction, that was paradigmatic. That was a conventional conveyancing transaction. The second transaction with which we are concerned was not. And so what I propose to do, if I may, is essentially turn some documents and show the court how the circumstances evolved and why it is that we say that that evolution gives rise to the arguable duty. What I propose to do is to ask the court to have the witness statement of Mr Gilbert to hand, together with his exhibit. I have extracted that witness statement because it's perhaps helpful to look at the two sets of documents together. It's a matter for the court. I'm mainly going to focus on the exhibit, but I will make some reference to what the witness says.
So remind us, where do we find that?
So we have supplemental title, witness statement behind tab 1. Tab 1, page 7.
Yep.
So what one has, of course, is a witness statement from a solicitor. It has been carefully prepared, and we recognise that as far as it goes. I'll make some observations later as to matters relevant to the second ground of appeal, disputes of facts and points like that. But taking the statement at face value, The witness introduces himself in paragraphs 1 to 3, refers to documents in his possession. Now, documents and the evidence is an important part of all of this. The witness does not claim to have carried out any particular searches for documents. We have not had disclosure. Paragraph 3 of the statement makes it clear that there is an exhibit of some copied documents. But we don't accept, insofar as it is suggested by the respondent in their skeleton argument, that we have had something equivalent to disclosure, because as we will see, there are certain notable omissions. And in any event, there has been no disclosure order. We've not even got to the CMC in this case. So paragraph 4, the witness is an experienced conveyancing solicitor, including in fraud cases. Paragraph 5, his first instruction in this matter arose following the FLP fraud. So he came in to these events after the first fraud. He refers to a letter of instruction dated the 29th of April 2008, not being exhibited or disclosed, and substantial emphasis is placed on, by the respondent on the terms of the retainer. We don't know what the retainer was or what the instructions that the bank gave to the solicitor were. We can surmise that it was in the nature of a general instruction, namely protect the bank's interests as best you can. But it certainly appears that Mr Kilbert was given a very wide discretion as to how to go about implementing those instructions. But we don't know what they actually were. So we see from the witness statement that Mr Kilbert interpreted the first fraud as being the theft of mortgage advances made by the bank. In paragraph 6, he sets out the background as he understood it. So he refers to the 2007 mortgage of Mr Ul Haq. The solicitor knew that Mr Atarian, the purchaser, also had a mortgage, also with the same bank. And he tells us, 5 lines up from the bottom of paragraph 6, that the monies had been misappropriated and the mortgage was not redeemed. So a confident conclusion which he has reached, one that we say is not necessarily accurate. It's not clear what analysis has resulted in that conclusion. And there's a point which remains unresolved in this litigation, which is not necessarily material for today, as to whether my client's mortgage was redeemed prior to the theft of monies or not. And the point being, just so I can make it to the court so you understand the background, it is unclear from the documents that have been produced whether the FLP theft took place after the mortgage monies had been applied to my client's account, such as to redeem the mortgage, or not. Because FLP acted for all 3 parties in the transaction, purchaser, vendor, and bank, it would require some examination of the ledger amongst other documents, and there's some indicators, including in this exhibit, that in fact the theft might have been upon the bank, because the mortgage had been redeemed prior to the time when the theft occurred. But we don't know.
Well, we know the bank didn't receive the money.
Correct, we know that. But its agent received the money, so the solicitor, FLP.
But as you pointed out, FLP were acting for everybody.
Yes.
So do you have a case as to whose money was stolen?
I don't know. I have a case that it could have been redeemed. The mortgage could have been redeemed prior to the theft. In those circumstances, it was the bank's money that was stolen. I say could have.
You mean one of the problems is the bank's acting on both sides of a transaction as well. But you mean Mr Ul Haq's bank, his mortgagee, it was their money that was stolen? Yes,
so it's the same bank who advanced the mortgage.
I understand that, yes.
So it is, yes, Mr Ul Haq's bank whose monies have been stolen. That is arguable.
But as you say, it's not necessary for us to resolve it.
No, absolutely not. So going forward, the claims against the solicitors are currently struck out. The claim against the bank was originally pleaded, and indeed on the current pleadings is still pleaded, as being declaratory only. What has happened from the disclosure of some of the information from the bank through Mr Kilbert's witness statement is that it appears, and I'll show the court this, that FLP treated the mortgage as having been redeemed. So in their ledger or whatever internal systems they've used, they've applied the monies received from the bank qua mortgagee of the vendor to the purchaser to the vendor, and then from the vendor to discharge his mortgage, the monies have been returned to the bank effectively. The bank never received those monies because of the intervening fraud, but if in the FLP ledger they appear to have been treated as having been applied to the bank's account. In those circumstances, the bank...
So you have an argument that his charge was discharged?
Yes, we do have an argument, yes.
But that's not been resolved, and it's not a matter between you and Mr Kilbert, it's a matter between you and the bank.
That's absolutely right. Yes. So the reason I raise it is to give the court a full understanding of the case, but it's also relevant to what Mr Kilbert was required to do as part of his investigation of the matters in which he was instructed. Because we know he has a fairly wide-ranging instruction and retainer, find out what has happened. He reaches certain conclusions which appear to be either mistaken or without proper investigation. And he takes steps by reference to those conclusions which he has reached, which ultimately result in submitting documents to the land registry in order to protect the bank's interests. That's what it ultimately arrives at. And the respondent says, well, that's all perfectly explicable because as far as the bank's concerned, it just wants to perfect its title so it can then obtain possession against Mr Rotarian. And I understand that is the bank's interest in all of that. But the issue is really whether that justifies the means deployed. So the end is perfectly understandable. The bank wants to prioritise its own interests over those of others. But does that mean that the solicitor has carte blanche to do as he sees fit, irrespective of the rights of innocent third parties? And that is where I say he does not.
Can I ask you, what I'm asking you as to what your case is?
Yeah.
Do you have a case as to whether in 2008 there was a contract of sale? Because there's been some ambiguity about it.
Yes, so there was a contract of sale, certainly, and there was exchange.
There was exchange of contracts. Yeah. That you accept.
Yes. So we then have, or if I may then show you the exhibits. So one starts, please, at page 34 after the list of exhibits. So this is what is described by Mr Kilbert in paragraph 5 of his witness statement as being the letter of instruction. On its face, it isn't a letter of instruction, or at least it appears to follow on from previous instructions that have already been given, not least because it says further to the above. But this is the first document from the bank, which gives us some indication as to what the bank's instructions to its solicitors are. And the accompanying letter is over the page 35. So the bank has received a letter from solicitors acting for purchaser, Mr Akarian, a letter dated 6th of May 2008 with someone's manuscript notes on it. Mr Kilbert deals with this in paragraph 7 of his witness statement. I assume they're his manuscript notes. He doesn't tell us. It probably doesn't matter. What I would say is this, though. The redemption issue appears to have been identified by whoever made the manuscript note. So see paragraph 3 of this. So the underlining of the redeemed, the mortgage, seems to suggest that the issue of redemption has been at least identified. And we see that later, the confusion as to whose monies have been stolen and what that means. And the second point we make in relation to this is that at all times, Mr Atarian was represented by solicitors. And one of the points we make about assumption of responsibility, and it's one of a number of points, and we say everything has to be considered in the round, is whether it was appropriate for Mr Kilvert to bypass Mr Atarian's solicitors, as he does, when he seeks to procure the backdated transfer deed, because that may well have been causative of the fraud that's ultimately perpetrated against my client, along with other matters. Then the next document, please, is at page 37. So this is the letter sent by Mr Kilvert to FLP. He describes this at paragraph 8 of his witness statement. And in this letter, he is asserting that the bank is the victim in respect of this transaction because it has suffered loss. And our specific case is referred to at page 40 of the letter. As the court will appreciate, there were a number of frauds that took place at FLP, different customers. So our case is dealt with in the PS at page 40. Since dictating the above, the client is notified as a further case of instructions issued from the Leeds office involving a borrower by the name of Atarian, property at 91 Argyle Road, mortgage advance of 1.125 million. We're presently awaiting papers. Please ask us for information. Then one then has a further letter from the bank at page 41. Dated 15th of May 2008. So, first point refers to a conversation of the same date. We don't have any file note of that conversation, and this is a point which I'm afraid we do see repeated frequently in the chronology, namely that there are attendance notes that Mr Kilvert makes, but they appear to be selective and many are missing. And why do I raise that? Reason is because paragraph 21 of the respondent's skeleton argument asserts that Mr Kilvert has a demonstrated practice of always keeping attendance notes, such that those that we do have are, it will be said, demonstrably reliable. To which we say, well, where are the ones then in respect of the conversations referred to in the documents throughout this exhibit that either exist and haven't been disclosed, or he doesn't actually have a demonstrated practice such as the respondent suggests. So the bank refers to purported completion on the 7th of March 2008. So the provisional analysis of the bank as of March 2008 was purported completion but no completion. And then there's an observation about whether Mr Atarian is genuine. So there is at least a concern, to put it no higher than that, that one of the parties with whom they're proposing to deal going forward might be a fraudster. So again, this is one of a number of points that distinguishes this from a conventional conveyancing transaction where one has no reason to think there's fraud infecting the transaction. This is a transaction which originates in circumstances where there has been a fraud and there is a suspicion that some of the people with whom the bank and the solicitor are proposing to deal may indeed be involved in fraud. So there's then a PS at the bottom referring to perhaps a different type of fraud. And what the bank says, we certainly know anyway that the monies have been misappropriated. And frankly, that is all we do know at this stage. Everyone knows the money has gone. Nobody knows from whom. So some documents were enclosed with the letter. Mr Kilbert then calls Mr Atarian's solicitors. So see please page 104. So file note of telephone call on 15th of May 2008. So same day as the call with the bank, for which we don't have the file note. And Mr Kilbert properly and appropriately dealt with Mr Atarian's solicitors, not Mr Atarian. He refers to the conversation with Mr Mills of FLP. We don't have that file note. He records the fact that Mr Atarian wants to purchase the property, and it's this which then appears to originate the process which results in the backdated transfer deed. So he sees this as the way to regularise, as he would have it, and protect the bank's interest. However, there's various complications which become apparent. So see please page 105, letter from Chequers Solicitors dated 22nd of May 2008, who tell Mr Kilbert that Mr Atarian is still paying the mortgage with the same bank. So the solicitor's being told that two unconnected parties both have a mortgage on the same property and they are both paying that mortgage. He doesn't appear to consider that that merits any particular investigation as to how it could be that a bank has two customers both paying mortgages secured over one property. And at 106, the notice of the claim against the solicitor's indemnity fund. And if I can then ask you please to look at page 111 when Gilbert writes to the bank. So it provides an update in relation to the various cases on which he has been instructed. He refers to a number of conversations with Mr Mills, none of which result in file notes. It's a discussion about various aspects of the case. So first, whether Mr Atarian is genuine, so obviously still some concerns about that. Secondly, whether or not there has been completion. Mr Kilbert's been investigating for several months and he still does not know, and he seeks the bank's views on that point. So that's pages 111 and 112. And at the bottom of 112, he asks for instructions on a number of points. In paragraph 3, top of page 113, he asks the bank, do I take it that it's your view that the fraudulent cases would have involved a conspiracy to defraud by individual borrowers acting in conjunction with those at FLP purportedly dealing with the conveyancing transactions? But he seems to have concluded that one of the borrowers, so that could be vendor or purchaser, has colluded in the FLP fraud, so either my client or Mr Atarian. Then paragraph 7, he's got specific questions about the Atarian file, second part of paragraph 7. And then paragraph 8, he asked for the full lending files on all 5 cases. So we can assume that he's not had those up to this point. And then over the page at PS on page 114, since dictating the above, I received your letter of 1st of July relating to Atarian. We don't have that letter, it's not been disclosed. And he summarises, though, what he's learnt from that. Then there's a response from the bank, which is at 115, dated 14th of July. So the bank says, this is 115, second paragraph, on the Etarian case, 91 Argyle work, as appreciate, we're not actually entitled to accept the payments that Mr Etarian is making. So there's no guarantee that even if we take possession, we'll end up selling it to him. I'll refer this to collections. So the bank's position appears to be that Mr Etarian's payments should be returned, or at least they're not entitled to those. That thinking presumably changes in due course, because the ultimate transaction, which results in the backdated transfer deed, is designed to allow for possession against Mr Etarian because he is in arrears. So there's some change in thinking in circumstances in which they seem to accept that Mr Etarian should be treated as being the correct title holder, but he falls into arrears, and it's on that basis that they seek possession against him. So the thinking at some point moves along, but at no stage does anyone stop and think about my client, Mr Haq's interests in all of this. Then there's some responses to the specific comments at page 116. So paragraph 2 on page 116. So the bank has raised inquiries with FLP. And again, it's important, given where we are. We've not had disclosure from the bank, so we don't actually know what the bank's own internal investigations into all of this show. We know that they exist and that they've carried out an investigation. But because we've still yet to get to disclosure, we have not seen that material. In paragraph 3, bank's view. So they don't take the view that all these cases involve fraudulent borrowers, and the bank believes Mr Etarian is an innocent victim, and it's possible that perhaps there were no fraudulent borrowers, but there could have been some identity fraud. And paragraph 4, for the lending criteria, etc. So the final two sentences. It seems irrelevant how we decided on lending figures. The only issue of relevance is that our money has been stolen. And that is a fairly stark, but we say instructive statement as to what the bank's position is. They say, well, we've not been paid, and therefore that's all that matters. Then paragraph 7 makes the point that the bank's going to investigate Mr Etarian. I made my point that we don't have the results of that. But they seem to be saying this is all very straightforward. Paragraph 9. As to whether it is very straightforward, we say, well, plainly not. Mr Gilbert then receives a letter from Mr Etarian's solicitors. This is page 120, letter dated 9th of January 2009. So this is Jones Solicitors acting for Mr Etarian, asking whether the bank will consent to registration. At 121, Mr Gilbert replies, saying this unilateral notice has been entered. Then 126, Jones Solicitors write again. Saying Mr Etarian wants property to be registered in his name, and they say that the bank has agreed to that. So see the 4th paragraph. So please consent to registration. We understand the client has spoken to the Bank of Scotland and it's possible to secure their consent, or at least agreed or may well agree. And in his witness statement, paragraph 17, Mr Gilbert states that he didn't understand the basis on which they thought that Mr Atarian could be registered as a proprietor. That is, of course, what he later arranged. So he obviously does become comfortable with that, and that that's the right thing to do eventually.
Where does he say that?
So in witness statement, paragraph 17.
Does he not simply mean that he's not on the register? So how can he become proprietor? There isn't. At this stage, he's had the bundle of documents from the bank showing that the transfer was not witnessed, hasn't he? Or has that come later?
No, he's not identified that yet. That's my understanding of the evidence.
Right, okay.
He's got the documents, or at least he's got some documents which were attached to the letter which I showed the court a moment ago at 41.
Yes, no, he hasn't had the TR1 yet.
No.
No, right. But if you look at the next sentence
of the witness statement,
yes, he says he spoke to someone at J.R. Jones and explained that the purchase had not been perfected.
Yes.
However, if it was the case that the property had been transferred but not registered, then it could be registered. So is he not simply saying, I don't understand how it can be registered? It depends on whether there's been a transfer. If there's been a transfer which hasn't been registered, then he can be registered, but otherwise he can't be.
Yes, I think that's probably fair, my lord. I think that is what he's saying at 127. In his witness statement responding to 127. Yeah. Then the file note, my lord, as you might point out, 14th of May, A9 file note makes these points. So he knows then that the registration is with Mr Haq, and he is not going to be able to register. And he's essentially seeking clarification as to what they are asking him to do. That's my interpretation of this file note. And then what he says in paragraph 18 of the witness statement, he says, I spoke to the solicitor, Miss Popat. She said that she thought the transfer had been completed, and it was for this reason he was maintaining mortgage repayments. Paragraph 18 says, I said this was something of a surprise and would follow this up. He said he knows that the mortgage repayments are being maintained at this point. And then he says, I did say that the deceased charge of 2007 had not been redeemed. This was the first intimation that we'd received there might possibly be some evidence that Mr Atarian had completed the purchase of the property. So that's where he learns that the documents might well demonstrate what's been described as completion.
And that's the attendance note at page 129.
Yes. And he identifies what he says is if FLP was purportedly acting for both parties. So this is after a year of investigation and doesn't appear to have appreciated that they were acting for all parties and the bank, but there we are. Then next file notice at 1:30, the bank calls Mr Kilvert. We discuss this case further. So it's now being indicated that Mr Atarian had generally purchased this property from the current borrower, Ul Haq, and I was therefore advising we should pursue this further. And Linda agreed. I don't criticise at all, it's very sensible. If in fact evidence was provided that Atarian had bought the property from Ul Haq, then if the Ul Haq mortgage was materially less than the Atarian mortgage, it would be worthwhile trying to resolve the issue. Not entirely clear what he's getting at there. I was, however, somewhat doubtful, and of course FLP has said that this and the others were all cases of fraud, but on the other hand Mr Mills of FLP was probably so punch drunk that he just more or less assumed that everything was a fraud, whether or not there were some genuine cases. Linda agreed, and then there's discussion about the state of the Haq account as to what the balance is that's outstanding and the arrears. So we are still at the stage of trying to understand what the parties' respective rights are. 131, email of 3rd of June 2009. So they say, clear from my discussion, there's only partial funds on the compensation fund. Client instructed FLP to purchase, and client continues to pay the mortgage instalments. FLP failed to redeem the seller's mortgage, they say, and further failed to register our client's interest in the property, thereby causing our client significant losses. Our client simply wishes to have his interest protected as he continues to make payment on the mortgage, requested the conveyancing file, but they failed to respond. So another evidential piece of the jigsaw as to what's actually happened. And 132, the file note of 10th of June 2009. Mr Kilbert says, Profits called him, received her email. If any consideration was going to be given to the suggestion by Mr. Terry that he actually purchased property, then we would need the following information. Then 1, 2, 3, 4, 5. So 4, would Mr Ul Haq be prepared to cooperate and, if necessary, sign replacement documentation? So one sees then the emergence of the idea whereby Mr Ul Haq will be persuaded or asked to sign a transfer deed, which will ultimately allow the bank to secure its property rights. So it originates, it would appear, with the solicitor. Now 134, letter dated 19th of June 2009, which essentially follows up with those questions. And the response at 135, dated 31st of July 2009, Mr. Atarian's living at the property, completion statement and a letter from HMRC, no means of contacting Mr. Ul Haq, 3 and 4, and then some documents are enclosed. Mr. Kilbert deals with this at paragraph 23 of his witness statement. He says exchange quite possibly completed. That's about 10 lines down in paragraph 23. So he says, from my review of the documents, it appeared to me the sale transaction had quite possibly been completed in the sense of an exchange of money for transfer, but not, of course, followed as it should have been by registration of dealings. Although I had not seen the completed transfer document that should have been exchanged for the purchase monies. What was clear was that there had been a failure to redeem the 2007 mortgage. That would in turn suggest there had been a failure by the solicitors acting for the deceased properly to pay part of the purchase monies to HBOS in respect of sums due under its existing registered charge. So if he reaches that clear conclusion, whether that's right or not is another matter. And then he says, this view was vindicated when I received the letter of 30th September 2009 from HBOS, as mentioned below. Now, all he's actually told, though, by HBOS, and I'll show you the letter in a moment, is that the bank's not received the money, and that's uncontroversial, but doesn't deal with whether its agent has received the money. So this is when we do receive the documents, including the defective TR1. So the file is enclosed with the letter of so 138 onwards, and then page 229 is the TR1. I can show you that, please. So this is undated, see box 4. And box 13, that is Mr. Hack's signature. And that is not witnessed and therefore not effective as a deed.
Sorry, which page are we on?
230.
Thank you.
Then 252, please.
Sorry, can you help me?
Yep.
There's another TR1 at 231 and 232.
There are in fact three. There's another one at 233 as well, which has Mr Atarian's signature on it.
Yes, that's right. So there are different ones, but none of them are signed. Sorry, witness. If I may, 2252.
Sorry,
Yeah, sorry, my lord.
it probably doesn't matter, but is there any explanation into the evidence as to why there's three such documents?
Not that I'm aware of, no.
Thank you.
252, please. The 252 letter from the bank dated 30th September 2009. There's some correspondence from the system. Purporting to send redemption monies. The account has never been paid. Not sure what that is referring to in this letter. There's a specific reference to an FLP later of 18th of April 2008. We don't have that. There is no letter dated 18th of April 2008. And what we do have is the letter at 220, which is a letter of 27th of March 2008 from FLP, which states that the mortgage, i.e. the Ul Haq mortgage, referred to as the borrower, has been redeemed. Doesn't refer to a cheque. It appears to have been done by electronic payment.
Sorry, I haven't understood that. Why do you say there's a reference to an electronic payment?
There's a reference, so I'm at 253, my lord.
Yes.
And there's a reference to form END1, END1. And then if one looks at that, at 254, there's a reference, the chaps box is marked.
I see. Is this the form that goes to the land registry to have the charge discharged?
Yes.
Yes.
So it makes reference to there having been a chaps payment. That's the means of funds being sent.
Yes, I see. Thank you.
Mr Gilbert deals with this paragraph 25. He says there is a letter from FLP purporting to send redemption monies, but the account was never repaid. And he says it's not clear if the cheque bounced or no cheque was enclosed. So it doesn't appear to have considered the documents referring to the electronic payment. Then I made 255, attendance noted 21st of November 2009. This is really just Mr Gilbert setting down his thinking as of that date. The recording facts and papers have been received, and what he says is the inevitable conclusion is that the sale by Mr Ul Haq to attorney did take place, as this is evidenced by an undated but signed and unwitnessed transfer by Ul Haq and then a promissory note. I'm not showing you that because it's not significant and there's enough material anyway. That's part of the raw transaction. So he takes a view then that there has been what he describes as a sale in inverted commas. And 256 letter to the SRA and the bottom paragraph on 256, Gilbert's expressing the view that monies, what he seems to be saying is monies were received, should have been applied to the discharge of Mr Ul Haq's mortgage with my client. Says consequently it may be that this case where Mr Atarian should be claiming the sum required to redeem the charge, but with a proviso that he should authorise the completion fund to make payment to my client. So he doesn't appear to be giving consideration to Mr Ul Haq's position. He seems to think he's got an outstanding mortgage that's not being redeemed, but that it's Mr Atarian who should be making the compensation claim, not Mr Ul Haq. And his concern ultimately is that the bank is paid. And what he does, final paragraph, perfectly understandably, is that I have to, final sentence, I of course have to reserve my client's position in relation to both cases, should any further information be forthcoming. But I know there's still no dealings with Mr Ul Haq at all at this point. Then the SRA responds on the 2nd of March 2010, that's page 258, and they analyse it differently. Namely that it's the bank's loss of the redemption money, so see the second paragraph. And they say, paragraph 1, that they're going to deal with Mr Atarian's solicitors, J.R. Jones, and then they've got various other queries about the redemption statements, etc., and evidence of payment. And 260 file note, 15th of April 2010. What one sees then from this file note is that Mr Gilbert has decided that the way forward is to obtain the transfer deed from Mr Ul Haq. So he says this fifth sentence is also the issue of tracing Mr Ul Haq to obtain his execution to a transfer deed. There was a transfer deed signed but not witnessed, so would not operate as a deed. And then he provides J.R. Jones with Mr Ul Haq's address. Ms. Jones says she would contact her client to see if Mr Ul Haq could be traced. We then come to the first of two disputed conversations between Mr Ul Haq and Mr Gilbert. So, bear in mind, please, that Mr Ul Haq and Mr Gilbert have not had any dealings at all up to this point. Mr Ul Haq's case is pleaded at paragraph 24 of the amended particulars of claim, which are at bundle tab 17, or bundle tab 17, page 258. Particulars of claim, and paragraph 24 and 25 is the plea. So the plea is this, paragraph 24. In the spring of 2010, the deceased was contacted by 7 defendants, and in particular by Mr Michael Gilbert, a consultant at 6th defendant firm who was then acting for the 6th defendant. Mr Gilbert told the deceased that his clients wanted him to sign a fresh or replaced transfer document, and that he should attend the offices of the first defendant to see the second defendant and should take identification evidence with him. During the course of a telephone conversation or conversations, deceased told Mr Gilbert that he did not know the first and second defendants did not wish to go to their offices to discuss or transact any business in relation to the property, offered to travel to the seventh defendant's offices in Wolverhampton to see Mr Gilbert in connection with any documents that need signing and to discuss the matter with Mr Gilbert. And Mr Gilbert said words to the effect, "No, I do not want to see you," and insisted that the deceased should go to the first and second defendant's office, and the deceased refused to do so. That's the plea. Statement of truth on that document is at 277. It is signed by the former solicitors. The particulars of claim are settled and signed by counsel. Mr Gilbert, it is right to acknowledge, disputes that. See paragraph 29 of his witness statement. So he says this at paragraph 29. I note paragraph 24, the particulars claim, it's alleged I contacted the deceased in spring 2010 and asked him to attend the offices of Leicester Dominic Solicitors to sign a replacement transfer deed. This is completely untrue, no such conversation took place. I did not even have a telephone number for the deceased, as can be evidenced by my later attempts to obtain one. My one and only conversation with the deceased took place on 9th of March 2011 as detailed below. I'd also state that had such a conversation take place, I certainly would have made an attendance note of such a conversation. My one and only conversation with the deceased was on 9th of March 2011 when he telephoned me as stated in paragraph 48 of this witness statement. Now, a lot's been made about this dispute of accounts in terms of the conversation. Fundamentally, my case does not rely upon me establishing the truth of either of these two conversations. I can make my case by reference to what the documentary record shows in terms of assumption of responsibility. But I do say that it is wrong in principle for the respondents to say that it is inevitable, the summary judgment threshold, that Mr Gilbert's account will be preferred and that we will lose. The reasons that are advanced are this. Paragraph 8 of the skeleton argument, Mr Ul Haq is now long dead, and therefore all we have is a statement of truth. And they assert that there's no basis for supposing that there will be any further evidential material that may arise. Which we say, well, we do have a pleading, which is signed with the statement of truth and has been settled by counsel. We haven't had disclosure, including from Mr Gilbert, or indeed any other party. It isn't the case that, in fact, Mr Gilbert's general evidence is as reliable as he asserts at paragraph 29, because paragraph 29 itself is inaccurate. There is an inaccuracy in there as to whether Mr Gilbert did indeed have the deceased's contact details, and I'll make that good in due course. But we say this is summary judgment. You have limited tools for resolving the matter. You really have to have a high degree of confidence that the solicitor's witness statement account is going to be preferred over that of my client. And I say that this is a case where one simply shouldn't have that high degree of confidence, because the only basis on which the respondent is saying that you should is because Mr Gilbert A is a solicitor and B is meticulous and reliable in his witness statement.
How are you going to establish at trial, in the absence of Mr Ul Haq, his version should? How are you going to evidence his version at all?
How am I going to establish at trial? I would do it in the way that I would seek to establish any disputed matter at a trial, and indeed, as my Lord would in my shoes, which is to cross-examine the witness by reference to the documents, ask the court to consider the inherent probabilities and relevant inferences that arise from the documentation, and then to make relevant findings by reference to the entirety of the record, and noting that witness statement recollections are not always as sound as one thinks. That is the reason we have a trial process.
Well, you may cross-examine Mr Gilbert to the extent that the trial judge is unable to place full reliance on his recollection. I understand that. But do you have any will you have at trial any positive evidence supporting the pleas in paragraph 24 and 25?
Well, the honest position is I don't know, because I haven't got to that stage yet. Because we've been struck out at this early stage, I'm not in a position to say what the evidence is going to be, which will allow me to effectively make good on the balance of probabilities what has been pleaded and what has been signed by a statement of truth.
The statement of truth is not evidence at trial.
No.
No. So I can see it's been pleaded, but
Yes.
you need to make your case out by evidence. And so you don't have a witness. It's unfortunate, but you don't. And
Today I don't.
today you don't, but there's no reason to think you will have a witness.
Well, my lord is speculating, respectfully.
No, I'm asking you.
Okay.
Because you can't go to trial saying, I hope something might turn up, but I've no idea where it might come from or what it might be.
Mm-hmm.
You go to trial by saying, here are disputes of fact which need resolving. This is the evidence on one side, this is the evidence on the other side. At the moment, we can see the evidence for Mr. Kilford. We can't see any evidence to support your pleas. And so I'm just asking, will the position be any better at trial? And I'm not sure that you do have any reason for thinking it will be any better at trial, but maybe I've misunderstood.
No, I'm not suggesting that I have in my back pocket a witness statement which is going to be determinative of this matter. I don't. I frankly admit that. But the point's as follows. The first point is, it does not matter, because my case...
Well, I have to add that.
Second point is, in any event, the stage of this litigation is such that we have got virtually nowhere. So we've not yet properly had an opportunity to investigate this case. There's been some preliminary investigations, of course. My predecessors, who were able to settle this document, have obviously carried out some investigations. The litigation commenced at a time when Mr Ul Haq was alive. So there are presumably documents, and I say presumably, I don't have them. I say that frankly, I don't have them. There is preliminary material that justifies the plea. I don't have it because of the stage of the litigation. If I was at trial and I was looking to advance the claim solely on cross-examination, i.e. that I put all of this to Mr Kilbert and he'd withstood my cross-examination, and I hadn't, in fact, made the progress which I would hope to make in terms of asking him to accept that he's wrong, let's just assume he sticks to his statement. The trial judge will say, well, what is it? It counterbalances what appears to be on its face very clear evidence from Mr Kilbert. And I would say, well, you have my evidence, it's limited. I've not made progress in cross-examination, I accept that. And there's nothing to counterbalance that. But we're not at that stage because we're not at trial. We've been struck out before we even get to see the documents. So it's not just a case of hoping that something will come up. There is material to justify the plea. There is what are described in the respondent's skeleton argument for today as infelicities in paragraph 29, i.e. it's not actually accurate. We know that there are further file notes out there which have not yet been disclosed. So is it likely that amongst that evidence there's going to be something to justify what is a fairly precise pleading in the particulars of claim? And the formulation of words that is used is precise. It must come from somewhere. How can you have the necessary level of confidence to say that I'm going to lose? And you can't, because it's just simply a straight clash of oral recollection, which is wholly unsuitable for summary disposal. So we say that this should be treated exactly the same way as every other trial, namely that at this stage we have the benefit of the doubt. Because why should it be any different from any other case? So I accept some of the force of the submission, namely that there is an evidential difficulty. Of course there is. That's absolutely right, and I frankly admit that. Is it insurmountable, or is it based on pure speculation and nothing else? We say no, it isn't. But it is only one point. It's one point amongst many in this case. If this were all about, for example, was an oral contract agreed, in the pub in Westminster or something of that nature, then it would be completely different. But this is just one evidential aspect of a far greater picture.
Thank you.
Next document, though, 262, please. So, file note of 11th of May 2010, Mr Terrian states he has a new solicitor, Guy Osborne. And what is said here is, please advise what forms need to be filled in. So essentially, Mr Terrian is keen to regularise this, and the bank appears to be keen too. What it now appears, and this is entirely with hindsight, is that on one view of events, one has a potential fraudster essentially asking the solicitor what needs to be done in order to execute what ultimately is accepted to be a fraudulent transaction. Then file note in 262, Mr. Gilbert refers to the precaution of verifying that solicitors have closed down. He knows, though, that Mr. Terrian has new solicitors, but rather than dealing with those solicitors, he telephones Mr. Terrian directly to tell him what documents need to be procured. And Mr. Terrian says, please send these to me, not to my solicitor. Mr. Gilbert doesn't appear to think there's anything potentially problematic about that. In 263, attendance note of 25th of May 2010. He recalls and says, no problem, essentially. So no problem with Mr. Ul Haq. What he doesn't do is stop and think about Mr. Ul Haq's position in all of this, because even on Mr. Gilbert's own analysis, Mr. Ul Haq has been defrauded and has an outstanding mortgage. He's not aware of any compensation having been paid or any regularisation of his circumstances. The purchaser, Mr. Terrian, is saying he wants to effectively arrange a transaction which will benefit the purchaser and the bank, but obviously not Mr. Ul Haq. Now we know he knows Mr. Ul Haq's address because he says so, but he hasn't, on his version of events, corresponded with him or even spoken to him. So he doesn't decide to communicate with Mr. Ul Haq at this stage. So what he does at 264, letter of 26th of May, is to write directly to Mr. Terrian, so not to his solicitors. And even at this stage, he appears still not to understand that FLP are acting for the bank, and he also knows substantial, he says there's substantial outstanding documentation missing, so first paragraph, so he still knows he's proceeding on the basis of a wholly incomplete evidential picture. And then he says, well, replacement deed, if this can be executed, then we can proceed. And over the page, he deals with issues of identification, need to be dealt with when making applications to the land registry. Next point needs to be signed in the presence of solicitors. So second paragraph, he explains that the documents are going to be backdated. So he gives gives the contact address to Mr Ul Haq in the final paragraph, 35 Inglis Road. He's basically telling Mr Etarian everything he needs to, as he would have it, regularise a transaction and transfer then away from Mr Ul Haq. And 26, so on C is then PR1, enclosed, the mortgage deed. 269, the chaser of the 10th of June 2010, asking for solicitor details. And 270 is a file note of 1st of July, referring to a conversation with Haq of 24th of June 2010. Again, we don't have that file note. He's explaining to himself why he thinks it's appropriate to call Mr Etarian directly. He's obviously concerned about that, because he knows Mr Etarian has a solicitor. He knows it's a new solicitor, Mr Osborne. And then he's told them the documents have been executed and will be received early next week. So on Mr Kilbert's case, still no contact from Mr Ul Haq, the fraud victim. So he then receives the replacement TR1. So this is the backdated one, which bears the inauthentic signature. So 274. So just to identify that, then that's the signature which is forged by reference to the expert report, at least on our case. Then Mr Etarian deals with this at paragraph 37 of his witness statement.
Just before we get there,
yeah.
I see the attendance note at 271,
yeah.
Recording receipt of the transfer. There isn't exhibited nor mentioned as existing any form of cover letter or anything of that nature.
No, that's right. So, yeah, it doesn't. I think he does say in his witness statement, it just came. Yeah, he just says we received in the post the transfer deed. He doesn't say there's any letter. That's paragraph 36 of the witness statement.
Yeah. Well, last line, there was no covering letter with the document.
Oh, thank you, my lord. Yes, thank you. That's right. So he did effectively a visual check himself, paragraph 37. He says, given the history of this matter, so he's obviously rather unsure about what he has received, given perhaps the absence of any contact with Mr Ul Haq, and given that it is on its face manifestly against Mr Ul Haq's interest to do this in those terms. He says, check with solicitors who said that Mr Etarian has a different property address. That's paragraph 37. And then he obviously does see the appropriateness of giving this further thought. He could have just registered then, but didn't. So 276, file noted 13th of July 2010. He records the fact that he's got the transfer deed, and it's witnessed. So both witnessed. So Lester Can of Lester Dominic, Mr Etarian's signature witnessed by Olga Marsh. So second paragraph, this is something of a comfort, and I did go through the documents which I had on the Etarian file. The only document which I have bearing signatures of Ul Haq and Etarian is a photocopy of an undated unwitnessed transfer, and signatures do appear to be the same. However, I have to be careful about this case, and I first of all telephoned Lester Dominic to speak with Mr Can, who witnessed the Ul Haq signature. He wasn't immediately available, but I was told that someone would ring me back. He says he called Olga Marsh. Then over the page, I received a return telephone call from girl Sana of Leicester Dominic Solicitors, who told me Mr Khan's assistant and he was out. Nature of my inquiries to the evidence identification of Mr Ul Haq. She said she would ask Mr Ul Khan to ring me on his return to the office. He'd not phoned me back by lunchtime, so I'll try again. So he is, as we say, is appropriate, clearly concerned to be careful given what he knows and also what he knows that he doesn't know about these transactions. In 278, so file note of 13th of July 2010, so Mr Khan telephoned and said that he had witnessed his signature, had not seen evidence of identity. And Mr Khan, for what it's worth, his witness statement is different, but that's not particularly material for present purposes. As matters stand, Mr Kilver knows that there's been a witnessing of the signature, but there has been no identity verification. So query then what reliance he can properly place on that. And 279, with regard to the identity of such Mr Ul Haq, and his address was as appeared on the electoral roll. And then he sets out that he's concerned. He says, I'm slightly concerned about this. This is 7 lines down. Signature of Mr Ul Haq on transfer deed does appear to be from the same person as the photocopy transfer that FLP sent to us. And therefore, he asks the solicitor to obtain identity. So he's concerned, understandably. He's carried out a visual review, and it looks similar. He's not to know that, in fact, it's a forgery, but he is concerned. You say that's perfectly sensible and prudent. And he says he's tried to obtain a telephone number, but hasn't. Then 280, letter dated 14th of July 2010, is sent to Mr Ul Haq. This is on his first dealing on the respondent's case, and they place very substantial emphasis on this document. We don't dispute receiving it, and there's a response to it in the pleading. So what the solicitor says, refers to how identity is required, all outstanding issues should be dealt with. The respondent's case is basically that perfectly obvious what Mr Ul Haq's being instructed to do by the solicitor here. We say, well,
sorry, just a quick question.
yeah.
One of the things that one sees straight away is that the address that he has from Mr Ul Haq is in Ealing.
Yeah.
Whereas the address of Leicester Dominic Solicitors is Ballards Lane in Finchley.
Yeah.
Not that close.
No.
And is he been given any explanation as to why the signature has been witnessed in Ballards Lane?
No, he has nothing at all that would amount to it. He doesn't even know, or at least he has doubt as to whether the person who has signed in Finchley is indeed Mr Ul Haq. Still less does he have any explanation, yes, I did do it, or anything of that nature. Or why it is I chose to go to Leicester Dominic, as opposed to just going round the corner to my local high street firm.
Okay.
Now, there's an issue about what Mr Ul Haq should have reasonably interpreted from this letter. We say, frankly, that a lot of these letters that are sent to Mr. Well, there's only two letters that are sent are hardly expressed in a particularly user-friendly English, for want of a better expression. They're extremely formalistic in their manner. What Mr Ul Haq says and pleads is at paragraph 35 of particulars of claim, 267, namely that he thought unless he did something, the transaction couldn't proceed.
All right.
So we say, well, that's his case. Whether his understanding of solicitor English should have been better is not really going to be determinative. That is what he understood from that letter. And then, again, and just to note then, the final paragraph of the letter at 280. Again, Mr Gilbert does know that Mr Ul Haq is a fraud victim here on his virtual events, because he's saying it's also in your interest that all the outstanding issues should be dealt with at the earliest possible time, since there are issues over the fact that FLP solicitors did not repay the money outstanding on mortgage out of the proceeds of sale, and consequently, until these issues are resolved, you, of course, continue to have a liability in that respect. So it's a rather casual statement, which is basically saying, yes, I acknowledge that you, Mr Ul Haq, are not going to benefit from this arrangement. You've got to keep on paying off your mortgage in respect of the property which I am seeking to transfer away from you. I don't appear to be in the slightest bit concerned by that. Now, second, two disputed conversations, and paragraph 28 of the particulars of claim. So,
Could I just ask you
Yeah.
about that? On Mr Kilvert's understanding,
yeah,
there was a contract between Mr Ul Haq and Mr Attarian. Mr Attarian had paid the purchase price.
yes.
So was Mr Ul Haq not, on Mr Kilvert's understanding, simply a bare trustee of the title for Mr Attarian?
Possibly. Don't you know? I mean, he doesn't tell us, so we're just putting it together.
As a matter of law, if his understanding was correct,
Yes.
which is that the monies had been transferred,
Yes.
which is at least on one view of the facts your own position, because your view of the facts is that, at least a possible view, is that the monies went from the purchaser to the vendor solicitors and then to the vendor's bank. Then, it not being disputed that there was a contract, Mr Attarian was entitled to have the transfer completed.
Yes, so sort of the unpaid vendors lien, yes.
But he's not unpaid on this view of the facts.
Well, if the monies have been applied to his account, I mean, this is where it becomes complicated, but if Mr Gilbert thinks that he has been fully paid, then yes. We don't know if he does think that, whether he's been fully paid or not.
Yes, okay.
All right, where do we go next?
Right, so, yeah, particulars of claim. Up to paragraph 32, plead case, he told Mr Gilbert that he'd never been to the first and second defendants' officers and had not signed the 2010 transfer. 285, I'll deal with Mr Gilbert in a moment. So 205 was finalised 23rd of July. Mr Gilbert saying that he needs identification, or at least he's seeking to obtain identification before proceeding. And 288, file note of 28th of July 2010, assistant telephones Mr Dominic, still no identification evidence, and suggesting that they should go and see Mr Ul Haq and verify. And then at 289, it's a letter from Mr Dominic which demonstrates that that's been a failure. So, having got anywhere with Mr Dominic in terms of verifying the signature, there is then the telephone conversation which is recorded in Mr Gilbert's file notes, so 293. So it happens whilst he's dictating a different telephone, a different file note, or in the course of an unrelated file note. So it starts in 294, third paragraph. Later in the afternoon, I received, somewhat surprisingly out of the blue, a telephone call from Mr Ul Haq. He sounded extremely concerned. He told me he tried to contact me at this office many times. This is absolutely, of course, untrue, as I have left messages to which he's not responded, and I've written letters which he has ignored, and I pointed this out to him, and he didn't dispute this. So first point, there has been previous telephone calls from Mr Gilbert to Mr Ul Haq, contrary to what he said at paragraph 29 of his witness statement. And he refers to letters in the plural. He's only produced the one letter, which is letter 280, dated 14th of July 2010. So we do say there is cause to doubt the reliability of Mr Gilbert's recollection. Then he says he then changed his tune, saying that he'd made many telephone calls to the bank, and it's the bank who'd given him details. And then we have this rather dismissive position of Mr Gilbert to Mr Ul Haq, when he says an employee of FLP has committed criminal offences, and he now advises Mr Ul Haq to make a claim to the compensation scheme. He's told him he might need a solicitor. And then he tells him what he wants him to do on his version of events. He says, I'm wanting him to make arrangements to see Mr Canagan and produce evidence of his identity by way of, for example, his original passport. So there's no doubt that this call did occur, and that's Mr Gilbert's version of the call that's pleaded to paragraph 32 of the particulars of claim. My client says he told Mr Gilbert that he hadn't signed the transfer deed. So it's slightly different from the first conversation, because here there's no dispute as to whether there was a conversation. The only issue is whether summary judgment threshold, this file note is going to be determinative. Do I stand no prospect of establishing with Mr Gilbert, whether through an examination, cross-examination, by reference to the documents, or generally, that in fact it may be that he has misunderstood, not properly recorded what he was being told, or indeed he just simply overlooked it or didn't appreciate the significance of it. Don't need to assert fraud, not that case. What we're saying is that he just has not, in fact, properly recorded the events with which he is dealing.
How realistic is that?
What? That solicitors...
No, that your client, on this telephone conversation, which it's not disputed took place, that your client told Mr Gilbert, I didn't sign the transfer deed. It's not been recorded, doesn't do anything about it, proceeds as if it's been properly executed. Is that realistic?
Does it have inherent high probability of being established? No. Is it so far-fetched that it could never be proven? No. So it sits in an evidential position between those two.
But it requires accepting that Mr Gilbert, who on the face of it, appears to make detailed attendance notes, certainly of the ones we've seen. I have your point that we haven't had everything. Should not only fail to record what would have been a very striking assertion, that because he's ringing, speaking to Mr. on his account, Mr. Ul Haq rings him, but he's telling Mr. Ul Haq, you've executed the document, I want you to go back to the solicitor who witnessed it and produce evidence of identity.
Yes.
And that's exactly consistent with what we've seen elsewhere. That's what you would expect him to say. If Mr. Ul Haq then says, but I never signed it, it would be astonishing for Mr. Kilvert not to react in any way at all.
Yes, it would be. The cases are rarely as stark as that. They're often far more nuanced. So, what is the actual conversation that took place? We don't know. We have to do the best that we can. Am I able to, or will I be able to demonstrate that Mr. Ul Haq said something along the lines that he pleads? It may be that his recollection is also imperfect, and that in fact he gave the solicitor cause to actually doubt what otherwise he read. That is possible. Our general case here is that Mr. Kilvert is essentially blinkered. He is at some point ceased to act objectively. We see this later, and he effectively determines that his instruction requires him to proceed, notwithstanding all of the doubts that he has, because that is the instruction from his client. An important client, the bank have instructed him on a number of files. At some point, I don't know when it is, and I don't need to say when it is, he does cease to act in a way that properly acknowledges and gives consideration to the interests of others, i.e. my client as a victim. But my Lord, I understand why the court puts it to me in those stark terms, because as matters stand today, we just have a stark conflict between the particulars of claim and the power motion. There's not much I can say without the process which we say to which we're entitled, and having the disclosure and understanding whether in fact this position is more nuanced. And that's as high as I put it. And I say this is why this isn't a case where everything turns on to conversations anyway. There's too much reliance being placed on that point and on the inherent probability of the solicitor being preferred over my client.
Well, it's not just that. It's that what you have pleaded is impossible to reconcile with the attendance note taken at face value. So if we look at 294 at the bottom, where Mr. Kilvert recites what he has said to Mr. Ul Haq on the telephone, and he says he had previously seen Lester Khan, who witnessed his signature on the replacement transfer deed, and I'm wanting him to make arrangement to see Mr. Khan again and produce evidence of his identity.
Yes,
now, the proposition that Mr. Ul Haq had in fact said to him in the course of the conversation, I never went to Lester Dominic, didn't sign, is simply impossible to reconcile with that passage in the attendance note.
Of course, I mean that's the point. It is impossible to reconcile. That is absolutely right. It requires me to establish with the witness that this is inaccurate for whatever reason. Maybe it's an infelicity of recollection as it's put in the respondent's skeleton argument. He's simply just not properly recorded the conversation. He wasn't listening to what Mr. Ul Haq was telling him. That is a possibility that cannot be excluded. And that is ultimately our case. And it isn't one that is based purely on speculation. So it is a striking thing, but that is what courts are here to deal with.
Thank you.
Letter then, outward letter 296. It's 11th of March 2011. And again, respondent makes the point, well, this is supportive of our case. Frankly, the solicitor English here is even more formalistic than the previous version. Mr Ul Haq's interpretation of this letter is the same, and that's what he pleads. He believes that unless he actually positively does something, nobody is going to be transferring documents away, transferring property.
Well, I can understand what you say about what's said in the third paragraph on page 296. But what about the top of 297? You have previously seen that Mr Lester Khan of Lester Dominic Solicitors of 8587 Bellards Lane, Finchley Central, London N3, and indeed it was Mr Khan who witnessed your signature on a replacement transfer deed which was forwarded to RCR Steer. That is perfectly straightforward English, and if the recipient of this letter had never been to Ballard's Lane, had not seen Mr Khan and had not signed a document in his presence, then it would be a very straightforward matter to say, what on earth are you talking about?
Yes, all things being equal, I agree. But we do say it's an individual who is not an English speaker, or a particularly fluent one. The evidence in poor health, he has a case which is that his interpretation of this was that if he didn't do it, then the transfer would not be executed. I take my lord's point. You might say, well, anybody would recognise that and interpret that as meaning, well, you need to speak up now, and he didn't. So where does that take you on the evidential journey? I mean, you could say, respondents, that it entitles Mr Gilbert then to be sure, because even though he's not received any positive response to this letter, he's at least raised it, and therefore he's passed the obligation on to the recipient to speak up. But why does that follow automatically? Is that a proposition of law, or is that just an evidential point? And that is the respondent's case, and I accept that. But we do have a counter case to it, which is not an English speaker, poor health, and he interpreted it in a different way. And that's really the point. So then that's it in terms of the dealing. So we then move straight on to the events which result in registration. So 298, bank says, please take urgent steps. This is the point I was making before. Client says, look, you just do this now. The reason is because Mr Terry's in arrears and they want to repossess. And it's this which is basically the respondent's case. They say, bank's our client, we do what the bank tells us to do. It doesn't really matter about anyone else. So they do. 299 then, letter of 21st of June 2011 to the Land Registry. And page 300, this is the AP1 application form. If we can just spend a few moments on this. So this it's not the TR one, this is the AP one.
Yep.
It identifies then council, the title. Paragraph 5, we see the documents lodged with the form. Transfer, charge, STRT certificate, so we know it's the same transfer that I've shown the court. That's the one at 290 with the forged signature. And box 6, the applicant is the Bank of Scotland. Box 7, reads page of the solicitors. And 10, 11, 12. And 12, please. So page 302, box 12, full details of the evidence of identity that is required can be found in Practice Guide 67 and Public Guide 20. 12, confirmation of identity. When registering transfers, charges, leases and other dispositions of land or giving effect to a discharge or release of a registered charge, Land Registry relies on the steps that conveyancers take where appropriate to verify the identity of their clients. These checks reduce the risk of property fraud. So that is what is important. The Land Registry relies on represented parties having had checks undertaken by their representatives. Second paragraph. Where a person was not represented by a conveyancer, land registry requires evidence of identity in respect of that person, except where the first alternative in panel 13.2 applies. It says what evidence of identity is. Then paragraph or box 13, where the application is sent to land registry by a conveyancer, as here. 1. Details of conveyance acting. If you are sending an application to register, transfer, lease or charge for each party to each disposition that is to be registered, state in the table below the details of the conveyancer, if any, who represented them. Where a party is not represented by a conveyancer, you must also complete 2 below. Then
and I understand you rely upon the fact that it's, as we can see, for Mr Ul Haq, it's stated that the conveyancers are FLP, reference Mr Mills. And I understand you draw attention to that, but can I be clear? It is not your case that Mr Kilbert deliberately put in FLP because he knew that he didn't have identity for Mr Ul Haq.
Correct. Not my case, never has been. When we look at the authorities, and the Supreme Court takes us through 6 of the previous cases in which assumption of responsibility has been established. 2 of those are cases where a solicitor has put something incorrect in a document which impacts upon the rights of a third party. No suggestion that the solicitor did that fraudulently or dishonestly. They just did it. I don't need to demonstrate, and I do not say that Mr Kilbert did this deliberately. What I am saying is that he did it, and having done it, that created responsibility. It's an assumption of responsibility.
So, do you say that the duty of care arose as at this date?
I say it doesn't matter because the tort occurs when the loss is suffered. It has arisen at this date. I'm content to say that, but I don't need to establish a date as to when it arose.
Why not? I mean, I appreciate it's not, as it were, a sine qua non of the cause of action, but analytically, if you're unable to point to the date when the duty of care arose, it casts doubt on whether there was a duty of care.
Yes, I take that analytical point, and I'm content to say that this document certainly is part of my case, and therefore, has it arisen prior to this date, I think I would still maintain an argument that the previous doubts are such that he should never have actually submitted the application at all. But as a fallback, he certainly should have never have submitted an application with a false AP1. So it's inherent in the way I argue this case that it is effectively a number of factors which contribute towards the assumption of responsibility. It's not simply just accepting the instruction, obviously. It's the way in which he performs the retainer which incurs the assumption. Has it arisen prior to this date? I think I would say yes on a primary case, but I do maintain that it doesn't actually matter. So, a two-pronged answer, but certainly as of the date of this form, yes. It's the direct answer.
All right.
Why does it matter? Well, it matters for the reasons that are perfectly evident from the form. So on 303, where a lender is not represented by a conveyancer, you must also complete 2 below. And that is because the land registry needs to be told whether it can rely on the steps that have been taken by the conveyancer to verify identity. And 2 is not completed because of the way in which 13.1 has been completed. So if 13.1 had been completed accurately, i.e. Mr Ul Haq is unrepresented, then they would need to complete 2, but they don't. So the land registry is relying on the accuracy of 1, and it is inaccurate. Not addressed by Mr Kilbert in evidence. Mr Cousins advanced arguments below that it's entirely normal because Mr Ul Haq was represented in 2008. Those arguments were rejected by the judge. but nevertheless disregarded in the overall analysis. And I say that that simply will not do. This is a contemporaneously dated document, C305, 21st of June 2011. It asserts a position as of that date. It doesn't purport to be a backdated document. And it does have the consequence that identity verification, which would be necessary, is circumvented. So what I ask is the point of the Land Registry having that process, if it can be legitimately circumvented in that way. 306, one sees then completion. 307, Mr Ul Haq calls again, saying he's received a letter stating the house has been transferred. And what's recorded is Mr Ul Haq asks what date the transfer took place and asks what's happening with the bank money. This is to Mr Gilbert's assistant, not to Mr Gilbert. And then manuscript note, I do not propose to contact Mr Ul Haq. He's previously ignored messages, letters and telephone messages. So again, high-handed, dismissive.
I don't think it says letters. I think it says correspondence.
Yes, thank you, my lord. So, yeah, correspondent and tele-messages. And that's it. So he's done his duty as he sees it. He's implemented his retainer. His transfer's been achieved. So who cares about Mr Ul Haq? That is it on the facts, and I propose then to deal with the law.
Yeah.
So, if I may, please, P&P. Familiar to many in this courtroom. So we say, and have always said, that a proper understanding of P&P is supportive of our argument and not contrary to our argument. So P&P, as the court will know, does the court have it? Have it then.
Yep.
P&P, of course, is an ordinary conveyancing transaction, albeit one which, unbeknownst at the time, was infected by fraud. No red flags, no doubts, no backdated documents, no undoing and regularising an earlier fraud, no dealing with known fraudsters, so completely different. Negligence is addressed from paragraph 62. So, court asks itself, I want to turn next to the question whether the solicitors and agents who act for the vendor owed any duty of care and negligence to the purchaser. So, the argument, of course, is a third-party liability argument. And paragraph 63, or just pattern, records then provisions of the judge. So paragraph 63, the judge rejected the existence of a duty of care primarily because he considered himself bound to follow the decision of Sir Donald Nichols in Gran Gelato, and there were no special circumstances in the context of the particular transaction to justify the imposition of a duty of care in favour of the claimant who was not OWC's client and was the counterparty to the transaction with its own solicitors. So that's Gran Gelato. Of course, what that recognises and countenances is that there will indeed be special circumstances in particular transactions which do give rise to the assumption of responsibility. There's a general rule, then there's a category of exceptions to it. And quote from Gran Gelato, so clear statement of the law for some time. In Gran Gelato, solicitors acting for the vendor on the sale of the leasehold premise gave a reply to an inquiry before a contract about the existence of adverse terms. Vice Chancellor held the vendor was liable in damages, negligence, and misrepresentation, but no duty of care. And that was because no proximity, no, not fair, just and reasonable on application of paro. So, Vice Chancellor accepted the test of proximity was established and that vendor solicitor has been taken. If known intended purchaser would rely on the accuracy of the answers to the inquiries. And the extensive quote at the bottom of 64. Generally, and this is my summary, normal conveyancing transactions where you have parties at arm's length, each represented by solicitors, they can each look after their own interests. I don't quarrel with that at all. Rather than reading it out, we just ask the court to consider that statement, which is, of course, painfully familiar. That goes all the way over the page, all the way through 307.
Do you want us to read all of that?
Yes, please.
All right. Yep.
And what the Court of Appeal correctly and properly takes from Grangelate, set out paragraph 65, PMP. So the appeals in PMP involved were in form and appearance ordinary conveyancing transactions, but in substance they were not, so unbeknownst to the individuals. It makes the point that fraudsters are unlikely to be traceable. Purchasers' own solicitors will not be in a position to carry out their own due diligence and can reasonably expect the vendor's own solicitors to have carried out the necessary AML checks as they're required to do. And then they say for this between B and C, it can therefore be said that the focus of the claims in these cases is on the duty of the vendor or solicitors to take reasonable care to ensure that the transaction is a genuine one, rather than on any duty to ensure that accurate information is given about matters such as title or physical state of the property to be sold. So I accept there's some parallel in terms of that argument, namely where you need to decide whether what appears to be a genuine transaction is a genuine transaction, and the Court of Appeal says no, not in the context of an ordinary conveyancing transaction. The reason is 66 onwards, is that cuts across the respective contractual position in an arm's length transaction, i.e. parties have their own solicitors to look after their own interest and they're at arm's length. And 69 deals with White and Jones. So language of the law there's in terms of proximity. What is said 69 and White and Jones, the House of Lords held that the failure by a solicitor to carry the instructions of his testator kind into effect by ensuring that a new will was executed was actual by the beneficiaries who would have inherited under the new will. The solicitor assumed a special relationship with potential beneficiaries whom he knew were economically dependent on his carrying out the testator's instructions. No conflict of interest and therefore no reason in policy not giving legal effect to the assumption of responsibility implicit in the proximity between the instructions accepted by the solicitor and those who intended to benefit under the will. Now, except, of course, White and Jones is another different example of how assumption of responsibility might arise, namely if it's reasonably in contemplation that somebody else is going to benefit from the instruction, they're the beneficiaries. And that, as a matter of legal policy, brings the parties into a proximate relationship. So far, so good. And paragraph 70, reference to Lord Goff's judgment, generally only a duty of care to the client, but that is only the general rule. Doesn't itself deal with the exception situation. And then again, another example, paragraph 71, McCulloch and Lane, Fox and Partners, so the misstated size of the garden. No duty. And then what is said at the bottom of 71, so between G and H, so the better view is a matter of legal policy. So the better view is that the decision in the grand gelate simply establishes the need, as in any other case where liability for economic loss is claimed on the basis of tortious duty of care, to take all relevant factors into account, including that the solicitor is providing replies on behalf of his client and will often be dependent on the client for the contents of the replies. This is a point which is then made again later, that we are very much firmly in the context of policy, nuance. These aren't hard-edged rules as to when there will always be a duty and when there will always not be a duty. It requires an overall evaluation of the facts and considerations of legal policy as to whether the duty should be imposed in the circumstances. Then 73 gives examples of cases where there has been a direct assumption of responsibility. And we'll come back to some of these examples in the context of the Supreme Court's decision in Enram in a minute. And 74, the imposition of liability and negligence towards the third party is not the solicitor's client, clearly requires something more than it being foreseeable by the solicitor that loss will be caused to the third party by a lack of care on the solicitor's part in carrying out whatever is the relevant task. Nor is it sufficient that the test of proximity is satisfied whether by an actual assumption of responsibility or by the existence of a direct interest on the part of a third party in the product of the solicitor's instructions. The incremental approach approved in Caparo requires all these and any other relevant factors to be taken into account and globally assessed, including any relevant policy considerations in deciding whether it is just or reasonable to recognise a duty of care. The approach enshrined in the case law requires the court to take account of the contractual framework and any other factors bearing on liability. And we say that that is important for a number of reasons. The cases will give you indicators as to where assumptions of responsibility are likely to be found, and P&P is one such case. But the incremental approach of the law doesn't mean that we are bound by those examples. One has to carry out a global evaluation of all of the factors, including relevant policy considerations. And this court does have a policy of imposing high standards of professional dealings upon professionals, not least solicitors. The time for that evaluation to take place is, of course, at trial, with a better or full understanding of the facts and proper argument as to what those policy considerations, properly understood, mean in the context of the particular case. And 75 refers to Enram 76, summarising Supreme Court's decision. So 76 says, Lord Wilson explains in his judgment the requirement that there should be an assumption of responsibility is to some extent a legal construct, in the case that in many cases the defendant, solicitor or other professional will be treated as having assumed responsibility to the third party for his actions by virtue of the proximity between them and the obvious effect which any failure on his part would have on the third party. There will rarely be an actual, conscious and voluntary assumption of responsibility, not least because the solicitor or other professional will have a client to whom he is contractually bound, that on the basis that the court is deciding whether to treat the defendant as having assumed legal responsibility to a third-party non-client for his actions, it will be necessary to balance the foreseeability that the third party will rely on the professional to perform their task in a competent manner against any other factors which would make such an imposition of liability unreasonable or unfair. So by definition, there is no contract, that much is accepted. So there's no answer for the respondents to keep making the point that there is no retainer between the solicitor and my client. That's not the point. The point is taking all of the facts as found, irrespective of what the solicitor thinks, has he nevertheless brought himself into a proximate relationship with my client by reason of his actions. For example, the submission of the AP1 form in the way that he did.
Well, you say that, and
Yes.
I appreciate you're in the middle of addressing us on the law, and so therefore I apologise for going back to the case. And it may be that, as with all of these questions, it depends on the responsibility that you're alleging has been assumed. Now, the reason I ask the question is this. It seems to me that one way of approaching this case is to assume against you, and I appreciate you're making submissions as to why we shouldn't, but to assume against you the disputed questions of fact as to the telephone conversations, and instead to proceed on the basis of what is actually common ground, viz. That as at the date of the AP1, Mr Kilvert had not had evidence of identity of Mr Ul Haq.
Yes.
That is, as I understand it, undisputed.
Yeah.
And so one could test the case, perhaps, by saying, when Mr Kilvert filled in the box 13.1 at page 303, identifying, you say wrongly, as a matter of fact, FLP as acting as conveyancers for Mr Ul Haq, and thereby not needing to complete box 13.2 and providing the evidence of identity, he thereby assumed a responsibility to Mr Ul Haq to that extent.
Yes.
Now, I can understand analytically a claim framed in that way, but that leads me on to two questions. Firstly, is that in fact how you put your case? Because it's not clear to me at the moment that it is. But secondly, if one proceeds on that basis that that's how the case is put, how do you get that within PMP?
I'll answer the second one first because it's PMP's in front of us on the page. So
Yeah.
paragraph 76 then. So just assuming, and of course as I say incorrectly, everybody agrees that Mr Ul Haq was not represented by FLP in 2011 at the date of the AP1. So on any view, that was inaccurate.
Yeah,
So,
and
yeah.
that's why I'm focusing upon that, because it gives you a solid factual foundation.
Indeed,
And it opens the door to you to say that in giving information on behalf of Mr Ul Haq,
Yes.
which is factually inaccurate, he's assuming a responsibility.
Yes, whether it is correct to say it's on behalf of Mr Ul Haq. I mean, formally it's on behalf of the bank, but it is capable of affecting the rights of Mr Ul Haq vis-à-vis the land registry. That's what the document does, because that's the purpose of submitting the form. So in those circumstances, if one just only takes paragraph 76, for example, so he's not intentionally assumed responsibility, but that doesn't matter. It's an objective construct. Is there sufficient legal proximity? Well, we say there must be, because he has been elected to put Mr Ul Haq down on the AP1 transfer form as a transferor, knowing that the consequence of doing that is that it will impact on his legal rights. So it is that decision to identify him which brings him into a proximate relationship, and thereafter, with that proximity, he has to then act reasonably and not carelessly in ensuring that the information provided is accurate, because the failure on his part will have an obvious effect on the third party. See line 6, paragraph 76. It must be obvious that the construct of paragraph of box 13 of the AP1 form is designed to ensure that people's legal rights are not affected in this way without there being a safeguard in place to ensure that they in fact do consent. That's the purpose of box 13. It must be. So, not an actual conscious and voluntary assumption of responsibility, no contractually bound, but if one proceeds on the basis that completing the AP1 is enough to create proximity, then the only question that's left is, well, what is the nature of the responsibility that arises by reason of that proximate relationship? And all I need to demonstrate is that it's a responsibility to complete the form accurately. take reasonable care to ensure that the form is completed accurately. Don't need to allege fraud, not alleging anything sinister. No doubt it was careless. So, the balancing question, and I didn't say I will win, but I do say it's arguable, but the balancing question, the final 4 lines, called balance the foreseeability the third party will rely on the professional to perform their task in a competent manner against any other factors which would make such an imposition of liability unreasonable or unfair. And the professional here is a solicitor. So a solicitor or conveyancer who is submitting forms which will create or affect legal rights. So a non-legal professional, whether or not he knows what is happening, it is immaterial. This is really just focused on the actions of the solicitor in performing that exercise. And then there may well be arguments to the contrary as to why it would be unreasonable to require a solicitor to complete an AP1 form accurately. I haven't heard any. And the argument from the respondents so far has been, well, it was perfectly understandable because he was effectively trying to recreate the circumstances as they stood in 2008. Now, the trial judge can listen to that argument. It didn't particularly persuade Mr. Justice Edwin Johnson below, and it's difficult to see really how that was likely to persuade anyone. But if that's their case, then they can make it, and the trial judge will balance that argument against my case. There's obvious proximity in those circumstances, and the obligation to act with a reasonable degree of care is hardly controversial.
But how do you differentiate this case from what was said about the AML checks in P&P?
Well, the AML checks aren't relevant to this. So here, this whole transaction originates with the solicitor. On my client's case, he's not a willing party to this whole transaction at all. So he has nobody protecting his interests in this because he doesn't believe that he's even party to it. So the AML issues that arise in the context of an arm's length ordinary conveyancing transaction, whereby, as a matter of policy, one can see that the courts would expect voluntary parties to an ordinary conveyancing transaction to ultimately look to their own interests and to make arrangements accordingly. So that's where the balance of justice falls down in P&P, and one can see that there's good policy reasons for that. The burden on the conveyancing industry would be excessive if they were to incur liability in respect of all AML checks to all third parties. But that's not this case. Ultimately, I'm not asking the solicitor to do very much that the court would consider to be objectionable to impose an unreasonable burden. Really asking him to ensure that he properly respects the interests of somebody whose legal rights he knows to be affected. Now, the AP1 form is effectively the easiest way to make the case, because it's very difficult to see the contrary argument. But the wider case is also open to is that what he knows is such that it puts him on notice that there's a third party whose rights are not being protected by his actions and require careful consideration. That's basically what it comes down to. First question. Nobody's saying I've not pleaded this. In the old version, which you appreciate I didn't plead, but I don't desire from it, it is there. It's in the existing version. I say the old version is still the current version, the amended particulars of play.
Well, let's start with the old version.
Yeah. So, what we've seen...
To just slightly cut to the chase.
Okay,
So
fine,
the reason why I asked the question is that I looked at paragraph 36, which refers to the applications to register the transfer. And based on your submissions to us this morning, one might have expected to see a plea that said, Mr Kilbert filled in box 13.1 with information that was inaccurate as at that date.
Yes,
and thereby didn't have to fill in 13.2 and provide the information as to identity.
Yes, absolutely. And the reason why, presumably, my predecessor hadn't included that is that they didn't have the benefit of Mr Gilbert's witness statement, which came on the summary judgment application to strike out this, in which all of these further matters became apparent, and that's why I put in a draft amended pleading, which, on any view, pleads that in terms.
All right, where do we find that?
Well, hang on. I say that paragraph 58 of the original papers of claim is the source of the assumption of responsibility plea against the seventh defendant.
Yeah, 58 is odd because what it doesn't plead, at least clearly, is the one thing that's not in dispute, which is that as at the date of completing the AP1, Mr Kilbert had not received evidence of the identity of Mr Ul Haq.
Yeah.
And knew he hadn't.
Correct. That is why I'm keen not to have to go down this route of the procedural history of... we went before the master. It was perfectly obvious that pleading required repleading, which is what I volunteered to do and did.
Right, so where do we find the plea that you're now relying on?
Well, tab 3 of the supplemental bundle. When you say relying on it, this is the document I produced to try and better articulate that case.
Which you never made an application to, formal application to amend before the court.
My lord, so I'll then deal with that. So this application came on before the master. I was instructed and did attend and said, well, no, this is actually far more complex and we should have an opportunity to replead. Master said, well, have you got a draft? I said, I will produce a draft and did produce a draft. That is the status of the document. So we'd already come on for the hearing before this issue arose. And what I indicated, as one often does, is that I wish to replead to clarify some of these matters. May I have the opportunity to do that? If there's some cost consequences, there we are. Master said yes, as one would expect, because it's perfectly obvious that the first version of the particulars of claim did require some changes. And what we pleaded then in the draft was the articulation of that. But then we got struck out. And I think we will get into the situation of, well, what am I supposed to do there? Am I still supposed to apply to rely on it? I don't know, is the honest answer. But I was struck out. This is what I would like to allege. And the claim against Reese Page is at paragraph 29 of 348 of the supplemental bundle.
Right, and where do we find the plea about the AP1?
So, background 31, 32, particular features. So I'm bringing the case within the exceptional category. Assumption of responsibility 34, and then specifically 34.10 would not submit any false documentation to the land registry as part of any transaction concerning the Argyle Road property. That's where I plead it. And my lord, I think, is saying, well, shouldn't it say AP1? Perhaps it should, but it's pleaded. No one's suggesting it isn't.
Well, by all means, show us well, if there's something else that you haven't referred to already. But as I said, what I'm wondering about at the moment is a case which is based upon facts that, as I see it, are not in dispute. Viz, that the key document is the AP1, which you've shown us is dated June 2011. You've shown us that box 31 is filled in with an inaccurate answer. And you've shown us that as a result of that, evidence of identity of Mr Ul Haq was not supplied. Mr Gilbert, knowing that he didn't have such evidence, and you have argued to us this morning that that in itself is sufficient to give rise to an assumption of responsibility for the reasons that you have just articulated, and I understand that case, but at the moment I'm struggling to find it even in the draft re-amended.
No, respectfully, my lord, it is there. The criticism as to whether it should be pleaded in a different way is a different one, but one has to read that also alongside the particulars of breach. Paragraph 44.
Well, just have a look at 4324 first. And all it says about the application to register the 2010 transfer is that it just gives a date.
Yes, but one has to read all of the relevant parts. So we read all of the facts from 34, 35, and then through to the particulars of breach. And we refer to the fact that he has not represented by solicitors.
44.9. Is that it?
Yeah. The court, of course, will be concerned to do justice. Nobody is saying that there is not a case, A, that is not, well, they're saying it's not arguable. Is it not pleadable or not pleaded? That is not a point taken against me on this appeal. No one is suggesting that even the new version not pleaded. That the case has been argued below twice on the basis that it's in the pleading. If it requires Part 18 further information so as to satisfy people as to what the cases they have to meet, then there we are. But I mean, if this case is going to turn on whether we need to identify by subparagraph the AP1 form error, I'd say that is not a just way of disposing of.
Yeah, I can quite see that this is a problem that may be susceptible to being cured, and I understand the submission that if a pleadable case is capable of going forward, then the court should allow it to go forward. But I was interested to see where it was at present. So we've rather taken you out of your course, which is my fault. Apologies. You were addressing us on the law.
I was, but I certainly don't want the court to be left with the view that we say it's not pleaded. It is pleaded. Could it be pleaded differently? Yes, we all have different pleading techniques. I accept that. Yep. And that can be resolved if there is an issue there. Right,
as you've explained, technically it's not pleaded, but it's in your draft.
Correct, my lord.
What you want to say.
What I want to say, if I ever get to a CMC, is I hope clear. The case that I wish to advance is what should matter here, because ultimately that's what this is all about. NRAM then, briefly, and I cover that, and just my criticism of the court below, but in a sense they'll be probably apparent.
Is there more in NRAM than the one gets out of PMP, which after all recites a chunk of it?
The only reason NRAM's helpful really is just the way that it draws together the 6 previous cases when there's different examples of when assumptions of responsibility have arisen, and all of that is rather contrary to the respondent's case, that it's extremely difficult for there ever to be any such assumption of responsibility, because In fact, you see all sorts of different examples. So it's paragraph 26. It's only because it's convenient to show you what the Supreme Court says about the 6 rather than taking the 6 yourself. And the more just illustrative of different situations. So paragraph 26, Court of Appeal of New Zealand and Allied Finance. Solicitor did something which was inaccurate in a document. The document intended to affect people's legal rights. Solicitor makes a misstatement in respect of it. No one's suggesting fraud. Doesn't matter. It's that act which creates the assumption of responsibility. So we say that would be a case on our side. That would point towards imposition of responsibility in analogous circumstances. It isn't just about the AP1, but that would be relevant to the AP1 analysis. Paragraph 27, slightly old formulation about the principles. But what I ask the court to take from this, then, the Midland Bank case, one considers the reference to the solicitor's calling. So the facts and the status of the person in question, the professional, is relevant. When we're talking about legal rights and obligations, a solicitor's actions in respect to that transaction will be different from, for example, a bank's actions. So it might not be the case that a bank would incur the liability, but the solicitor may, even if he is acting on the instructions of the bank. And I say that that should not be a controversial proposition. Paragraph 28, Al-Kandari. This is the case where the solicitor accidentally releases the passport to the embassy, Kuwaiti embassy, which in turn releases it to the husband, contrary to a court order. Liability is established there on the part of the solicitor to the wife. And the reason is given is because the solicitor has stepped outside his ordinary function. But that's just a different way of describing a different scenario in which a solicitor might incur third-party liability. It's not the test as such. It's a way of illustrating why legal policy would impose a duty in such circumstances. That's the first case, again, of relevance. And paragraph 29, grand gelato, we all know that, no general duty. Not proposing to say anything about that. And thirdly, Connell and Odlum, again, this is reliance on the truth of a formal legal document signed by a solicitor which transpired not to be true. This is the second of the two of the 6 which I said had that fact pattern, i.e. a solicitor incorrectly stating the accuracy of something in a formal legal document, which inevitably and foreseeably impacts on the rights of third parties. So again, sounds in our favour. And Dean and Allen, again, different fact scenario in which liability is established, but not of any huge additional significance beyond that. I understand the respondent wants to take you through all of those 6 in a lot of detail in their submissions, and I'm perfectly content to listen to all of that. But all that really tells you is that there are all sorts of different circumstances where legal policy militates in favour of the duty. That's my argument, and what my argument has always been. So that's all I wanted to show you from NRAP. It might be then that I can conclude in the 5 minutes that are there, just by setting out why I say the judge went wrong. So judgment, please, tab 7. So we're focusing on 92 onwards. So 92, 93, reasonable summary of arguments. 94, judge says this is very straightforward. We'll see why he says that in a moment. Paragraph 95, Reese Page was never instructed to act on behalf of the deceased. Obviously right. He never suggested the contrary. Reese Page was instructed to act for the bank, and then sets out what they were initially asked. They were initially asked to include the 2008 transaction in their investigations of various mortgage loans. Now, pretty broadly consistent with what we'd say. This is a general investigation instruction, and then an investigation to go on and take legal steps. And then the judge correctly identifies that there will not normally be a duty. So we don't quarrel with that. We've never said we're in the normal situation. In paragraph 96 to 99, the granulato, and the judge really just approaches this on the basis of whether this is covered by granulato and indeed ultimately P&P itself. So judge directs himself to the fact that granulato is good law, and that was my case too. We weren't arguing that it wasn't. That's 96 to 99 when he refers to P&P. And then an analysis of Lord Justice Patton. Well, it's a recitation of what Lord Justice Patton said in P&P through to 103, but that just sets out what the case decides, doesn't have to engage with the analysis. Now, 105 then is where the judge conducts his analysis. So basically, he says P&P is decisive, essentially because of the lack of a retainer. And this was the position of the master as well. I've quoted from P&P at some length because it seems to be decisive against the state case that Reese Page owed a duty of care to the deceased. Reese Page were not instructed to act for the deceased and did not agree to do anything for the deceased. Well, we know that. To the contrary, Mr Gilbert made it clear, as he recorded in his telephone notes, that he could not advise the deceased. So all of that is addressing, is not meeting our case in any sense, because we know that. This isn't about what he was consciously and voluntarily doing. This is about what the effect of his actions were, whether objectively, on a legal construct approach as required by P&P, he brought himself into a proximate relationship. And none of that is addressed. The judge just doesn't meet the claimant's case, nor, respectfully, does the respondent. So the judge has effectively embarked on the position that this is, P&P is determinative, which is a respondent's case, which we say it obviously isn't, for the reasons that I've already expressed in my submissions. Then the court resolves and deals with some of the disputes of fact summarily, and the court has my submissions as to whether that was appropriate. We say it wasn't, but in any event, my appeal should succeed on my first ground, irrespective of whether that was appropriate or not. So true it is, I don't have the evidence, and I've made argument on that. Then 111 just deals with the AP1 in a rather circumspect way. So it's possible to be critical of the way in which Mr Kilworth completed the application for registration. And I made my submissions today in the same way I made them today. It's not just a possibility of criticism, this is a fundamental problem. It says, I take the points made by Mr Brown, the land registry was not informed that the 2010 TR1 had been backdated, and the requirement to provide evidence of identity was avoided by specifying FLP as conveyancers acting for the deceased when FLP acted in relation to the 2008 transaction and had not been involved in the 2010 transfer. Mr Cousins argued the application form should be seen as speaking at the time the application form was lodged. Not be seen as speaking at the time it was lodged, but rather finding information in relation to the relevant transaction. And then the judge does say, for what it's worth, I doubt this argument is correct. It seems to me that the application form was concerned with, or at least included, the transaction constituted by the execution of the 2010 transfer, in respect of which the deceased appears to be unrepresented. It doesn't deal with any of the consequences of that. It just says at 112, I cannot see, however, that any of these matters assist the estate, either in establishing the existence of a duty of care. But why? Why have we lost on that point? And in any event, how is that possible on a summary judgment analysis? So he doesn't properly respectfully understand what PNP requires of him here, which is to consider legal policy, consider the situations in which third-party assumption of responsibility could be created by a solicitor doing this sort of action. Just says, well, don't see it's arguable. And the only reason why the judge has reached that conclusion at 112 must be because he considers that the retainer is effectively determinative and it occupies the whole field here. And in that situation, there's just no room for any third-party liability. That is not what PNP says. So we say he should, at least to the relevant threshold, have considered it arguable that we were in the second and the fifth examples in NRAM, the incorrect document examples, paragraphs 26 and 30, which I've shown you. Then 113.
Just before you leave, 112, he refers there to the estate's factual case that Mr Gilbert knew or ought to have known that the signature was or might be a forgery. What is your case? You don't say that he knew it was a forgery.
I do not say that. I don't know. I don't say that he knew that it was a forgery.
Do you say he ought to have known it was a forgery?
On the TR1, no, I don't go that far either.
No, I didn't understand you to.
No, I say.
Do you say he ought to have known that it might be a forgery?
What he did know informs what he ought to have known. So in the context of this case, he had concerns about the veracity of that signature as we have seen from the documents. So one has to look at it in the context of this case and this fact pattern. So in light of what he did know, i.e. that this was an atypical transaction, and therefore there was a risk that this was not his signature, then in those circumstances we say he ought properly to have obtained proper comfort in respect of that. So that's our case.
So he ought to have known there was a risk.
Yes, there was a risk. That's because.
No, I'm just trying to understand what your allegation is.
But again, one can put this in terms of matters that are common ground.
Yeah.
Because what Mr. Kilvert's evidence shows is that he at any rate appreciated that this was a case in which he should ask for evidence of ID.
Yes.
He did ask for evidence of ID.
Yes.
And he didn't get it.
Yes. So should he then have proceeded? He has an instruction from his client. So in those circumstances, does the solicitor have a duty to consider further whether it is proper to execute that instruction, knowing what he knows? That is how we have put it. Because the fact of the instruction is not determinative. The solicitor if a client instructs you to do something which you know you cannot, then of course the solicitor must say no. Here, he decides to proceed, because that's their case. They say, my instruction from the bank is to submit the transfer documents, and that absolves me of any responsibility to any third party who might be affected by my actions. And it's that decision that brings them into the proximate relationship.
The difficulty with that is you're obviously right. If a client instructs the solicitor to do something which he ought not to do, in the sense of it being unlawful or improper or misleading,
Yes.
then you can't obey those instructions. But if the client instructs you to do something which is lawful
Yes.
and not improper and not misleading, then the fact that in doing it you will necessarily damage someone else's interests can't stop you from doing it.
Well, this is where a degree of care is required, because it depends whether that damage to the third party's interests is legitimate or not to some extent, because there will always be situations when solicitors are instructed to do something which will interfere with another party's rights. If you enforce a judgment, then...
Yeah, every time you litigate against somebody, you are seeking to damage someone else's rights. Those are your instructions, and as long as you are instructed to do something lawful and proper, you have to carry them out, however disastrous it is for the person on the other side, precisely because they're on the other side. And that's the force of the point, that in normal circumstances, you don't owe duties to the other side.
Quite so. Quite so.
So you do have to be a bit careful about simply saying you shouldn't carry out instructions where they will damage other people, because most solicitors' instructions will have effect on other people's legal rights, and that's not their concern.
My lord, I agree. That is not my case. So what it is about the degree of care that is required in order to ensure that the instruction legitimately prefers the rights of the bank over the third party's rights. Because you're right, it's adversarial. So by definition, the other party, their rights will be impacted. But if that is legitimate, because there's a legal authority for it, i.e. here, an authentic signature on a legal document, then that is fine. No quarrel with that at all. So the third party has consented to it, and there's no assumption to it. But if what I'm describing as the indicators of red flag...
So translating that into my own words,
Yeah.
Do I understand you to say this? If Mr. Kilvert had sought instructions from the bank saying there is a problem with the AP1 because Mr. Ul Haq does not have a licensed conveyor acting for him, and I have no evidence of ID, and the bank had instructed him, go ahead, fill it in with outdated information, then you would say, as I understand it, fine, because he was then acting on the direct instructions of his client. Is that right?
No, I would not say fine. I'm not sure how the court has interpreted me. I would say the solicitor can't do that. Because the solicitor knows that's false. So he's identified the fact that submitting it on the basis of there being representation when he knows there is none, that can't be justified by the instruction from the bank, because that is intentionally false.
So how is your case better because he didn't have instructions from the client to do that?
The instructions from the client are completely irrelevant. He was careless in the way that he completed that form. If he had been careful, then he would have completed it genuinely or accurately, for want of a better expression.
But he couldn't. I mean, because what you've identified is that if he'd thought about it,
Yes.
he would have realised that he couldn't fill in the AP1 because he couldn't satisfy either of the two alternatives. He could not identify a licensed conveyancer currently acting for Mr. Ul Haq, nor could he supply evidence of ID. That's the force of your case,
Yes.
is he couldn't satisfy either alternative.
Indeed. So the bank says file, solicitor says no, I cannot. As a responsible solicitor, I cannot, because it is perfectly obvious that in doing so, third parties' legal rights would be unjustifiably interfered with as a result of doing that. That comes from his status as a solicitor. Whether there be liability on the bank for that instruction is neither here nor there. This is a policy factor that would point towards the solicitor then being responsible for that. And I say that can't be controversial.
You put in the word unjustifiably, which you have to put in.
Yes.
Because, as we discussed earlier, impacting on other people's rights is usually entirely justifiable.
Yes.
Because you're acting in your client's interest. So what makes it unjustifiable?
Completing the AP1 knowing that it's false.
Well, your case is not that he knew.
No, but on my lord's
No,
policy.
but go back to your case.
Okay.
Obviously, if you know it's
No,
false...
I said if he had thought about it.
Yes.
So you don't say he deliberately made a false entry. Your case is he should have thought about it.
Yes, okay. So he should have and failed.
So he's not doing something that he knows he shouldn't be doing. He's not carrying out his instructions knowing it's illegal or improper or fraudulent or misleading or whatever. He's been careless about it.
Yes, yes.
And you have to say that being careless about filling in the form is itself sufficient to generate the obligation to Mr. Haq to be careful. Is that right?
No, I say that the proximity is what I need to establish first, legal proximity. And I establish legal proximity, I say, when he decides to fill the form in, irrespective of the content. This is how the case would be brought. So what creates the necessary proximity is the solicitor's decision on instructions to complete an AP1 form, because he knows that third parties, purchase of vendor bank, will be affected by his decision to do that. That's what brings him into proximity with those individuals, including my client. Next question. He's now in a legally proximate relationship. What is the extent of the duty? Now I say it's a duty to take reasonable care to complete that AP1 form accurately.
Thank you.
It is 12 minutes past 1. Is that convenient? I'm basically finished, perhaps just 5 minutes after lunch.
Yes, all right. We will pause there and resume at 2:10.